Welcome, everybody, to today's episode of The Law of Self-Defense. I am, of course, attorney Andrew Branca for The Law of Self-Defense. A Florida deputy is helpfully teaching his girlfriend how to handle firearms when, oops, the AR-style rifle he's handling fires around through her head with predictably fatal results. No one investigating the shooting believes the shooting was intentional, and the man appears genuinely remorseful about his girlfriend's death, which he describes as the result of an accidental discharge. Nevertheless, the man's been charged with manslaughter and is being held without bail. In today's show, I'll explain why this is exactly the proper legal process. That's what we'll be covering in today's episode of The Law of Self-Defense. As always, I am attorney Andrew Branca for lawofselfdefense.com. Now, Florida Sheriff's Deputy Leslie Below out of Marion County recently decided to teach his girlfriend how to clean, dry fire, and otherwise safely handle firearms. Unfortunately, this deputy left out a key ingredient, and that was competence. While handling the AR-style rifle, the deputy discharged a round that passed through his girlfriend's head, and she naturally died of the gunshot wound. The deputy immediately called 911, told dispatch that he'd shot his girlfriend in an accidental discharge. He's now been charged with manslaughter, a felony good for 15 years and a $10,000 fine, is being held without bail, and has been terminated from his deputy position. Strictly speaking, something that's an accident carries zero criminal liability. So how could an accidental shooting result in a manslaughter charge? Because, for genuinely solid public policy reasons, the law simply does not allow for bad outcomes resulting from the handling of inherently dangerous instruments like firearms to be waved away as accidents. The law recognizes that genuine accidents are a thing in the real world and allows that something that is an accident ought to carry no legal liability. Indeed, there is a legal defense of accident that can be raised as a legal defense in court, just like there's a legal defense of self-defense to justify even the intentional taking of another person's life. But just as the legal defense of self-defense has specific conditions that must be satisfied, we cover those in our best-selling book, The Law of Self-Defense, the legal defense of accident also has specific conditions that must be satisfied. First, the legal defense of accident requires that the bad outcome, whatever it might be, must necessarily have been unforeseeable to the person accused of the conduct that led to the bad outcome. Imagine, for example, that you visit your elderly aunt in her upper floor apartment, and while you're there, she asks you, a strong young man, to move a piece of heavy furniture from one side of her apartment to the other. You're more than happy to help out, so you lift up the heavy furniture, carry it to the other side of the room, and set it down on the floor. Unknown and unknowable to you, the floor joists in that spot have been eaten out by termites, and when you set the heavy furniture down, it falls through the floor and kills another elderly lady who lives in the apartment below. Now, certainly killing an elderly lady is a bad outcome, but if that bad outcome was not reasonably foreseeable, it's a bad outcome fairly characterized as a genuine accident and carries no legal liability. Criminal liability doesn't arise until the conduct in question amounts to recklessness. Recklessness, in the context of today's show, this accidental discharge death, is the unjustified creation of a risk of death or serious bodily injury, deliberately ignoring that risk, and as a result, death occurs. A classic example of a reckless killing would be a drunk driving homicide. You get drunk at a local bar, then get behind the wheel of your car to drive drunkenly home. You're not intending to harm anyone. You're simply intending to get home. But we all know that driving drunk creates an unjustified risk of death or serious bodily injury to anyone who gets in your way. And that's the very definition of recklessness. If you then run over Granny in the crosswalk, you've committed a reckless killing, which is the crime of involuntary manslaughter. So the difference between accident, no legal liability, and recklessness, criminal liability, is that in an accident, the bad outcome was unforeseeable. And in recklessness, the bad outcome was foreseeable and the risk was intentionally ignored. There is a special category of conduct in which a bad outcome is automatically jumped to the level of recklessness. And that's when the bad outcome is the result of handling or mishandling an inherently dangerous instrument. Inherently dangerous instruments are things like heavy machinery, explosives, dangerous chemicals, and firearms. It's their nature that any mishandling can readily result in death or serious bodily injury. As a matter of public policy, it's assumed that anyone handling an inherently dangerous instrument is aware of the risk of mishandling, and therefore, if mishandling occurs, the person intentionally ignored that risk, the very definition of recklessness. So if you're handling an inherently dangerous instrument and death results, it can't be a mere accident, legally speaking. The risk was inherently foreseeable. But instead it jumps automatically to recklessness and criminal liability. In the case of a death, involuntary manslaughter. Again, the reckless killing of another person. All inherently dangerous instruments also have surrounding them a series of safety protocols that distinguish between safe handling and mishandling. And if these safety protocols are followed, a bad outcome cannot result. In the context of firearms, these safety protocols are the 4 rules of gun safety, and anyone handling a gun is presumed to be aware of these safety rules. They are: all guns are assumed to be loaded until verified otherwise, never point a gun at anything you're not willing to destroy, never touch the trigger unless you wish the gun to fire, and 4, know your target and what is beyond your target. If these rules are followed, or even if only one rule is violated, a bad outcome in the form of a lost human life cannot occur. For a human life to be unintentionally taken by mishandling of a firearm, some combination, more than one, of these rules must be broken. Typically, the gun was in fact loaded, the gun is in fact pointed at another person, and the trigger is in fact manipulated. And if that occurs, it's the result of knowingly mishandling an inherently dangerous instrument, in violation of these well-established safety rules, and that qualifies as involuntary manslaughter if somebody dies as a result. So legally speaking, it's almost impossible for there to be an unintentional shooting, death of another person, and for that death to be properly characterized as an accident. Almost by definition, it has to be recklessness, and therefore has to be involuntary manslaughter. So when former Deputy Below is handling his AR-style rifle and discharges a bullet through his girlfriend's head, legally speaking, it can hardly be anything but involuntary manslaughter. And as it happens, the facts in this case are even worse for Below. For one thing, not only is everyone who handles a gun presumed to know the safety rules discussed, as a deputy, Below would have been demonstrably trained on those safety rules, so it's impossible for him to claim ignorance of them. Second, Below and his girlfriend had just returned from having dinner out, during the course of which they had each consumed 3 margaritas. Not only is the mishandling of a gun automatically recklessness on the basis of firearms being inherently dangerous instruments, the alcohol intoxication alone would make this a reckless killing, even independent of that rationale, much as would be the case if the girlfriend had been killed by Below's drunk driving. As news reports indicate was cited in the arrest affidavit, quote, Below stated that he grabbed the rifle and dry fired it one time. Okay, well, when you dry fire an AR-style rifle, that involves cycling the bolt, pressing the trigger. You get a click if the chamber's already been verified as empty and there's no magazine in place that could feed a round into the chamber. However, the affidavit continues, on the second dry fire attempt, Below had forgotten that he placed the loaded magazine into the rifle. Well, that sure sounds like recklessness, because now, when he cycles for the first dry fire, he does put a live round in the chamber, and when he presses the trigger again, he fires the shot that kills his girlfriend. The arrest affidavit also indicates that Below himself described his handling of the rifle as sloppy. Well, sloppy handling of a firearm is always going to be reckless handling, and if an unintentional death results, that's always going to be involuntary manslaughter. Folks, I'm a lifelong gun owner myself. I've been an NRA certified instructor in rifle for more than 30 years. I'm an advocate for responsible exercise of our Second Amendment rights. But the key there is responsible exercise. If you mishandle a firearm and unintentionally kill someone, I'm going to be calling that involuntary manslaughter every day of the week and twice on Sundays. That applies equally to this former Deputy Below, to actor Alec Baldwin, and anyone else. Hey folks, if you'd like to gain genuine expertise in the law of self-defense so you can make more confident, better informed, more lawful, and more decisive decisions in defense of yourself, your family, your property, so that you're both hard to kill and hard to convict, you can now gain that expertise in a single day. In just a few days, we'll be holding one of our twice-a-year Law of Self-Defense Advanced classes. This is a full-day class taught live by me, live streamed to you at the convenience of your laptop, tablet, or even smartphone, and it makes you a genuine expert in the law of self-defense in just a single day. And for a short while longer, you can grab your ticket to this upcoming Law of Self-Defense class at up to 50% off the normal price at lawofselfdefense.com/advanced. Don't delay. If you miss this one, it'll be at least 6 months until the next class. So grab your ticket today at lawofselfdefense.com/advanced. And with that said, I'll just remind all of you, again, that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.